As always, the views expressed during today's webinar are those of the speakers, not of Stratford, the speakers' firms, or clients, and are not intended to provide legal or tax advice. We have gathered an estate planning expert to provide critical first look at the wealth transfer implications of the new tax reform law. Our speaker today is Jim G. Blase. He's a principal at Blase & Associates and an adjunct professor at Villanova University School of Law Graduate Tax Program. Jim, when you're ready, we'll go ahead and get started.
Okay, thank you very much. Just want to let everyone know that I'm going to get right into this today because there's a lot of material to cover, and I'm going to have to move very quickly, unfortunately. But at the end of the slides, there were 3 articles that I've written that basically cover all the material we're going to discuss today, so you'll be able to refer to those, and also feel free to email me after the presentation. Also on my website, www.blazelaw.com, there's a link to a book you can purchase from Amazon, which contains all this material and more material, and it also contains all my forms in this area, so that could be helpful too. I price that book on Amazon as cheaply as they permit, so it's only like $12 to get that. But the link on that is on my website. It's called Optimum Estate Planning. This is a very complex area that I'm going to be talking about today, unfortunately, but it's very important, and you'll realize that very quickly. It's going to affect all of your clients. Most of the estate planning I do is geared towards the typical client out there, not just for the ultra-high net worth. So I want to be sure you know that there's probably not very few clients you have out there where this topic won't be relevant. What I tried to do in this presentation and in this article was I tried to really answer one question. As everyone knows, the only real significant change in the estate planning area, which was passed by the 2017 Act, had to do with the temporary increase in the federal estate tax exemption from basically $5.5 million to $11 million. So that's simple enough. The more difficult feature, in my opinion, is to determine what is the relevance of that change. It's easy to say change, but how is that relevant in everything we do in estate planning? So that's what I'm going to try to go over today, again, as quickly as I can, and all the articles will be there. So we'll move on to the first slide. The first thing I want to mention was, again, with virtually all our clients out there, we use trust for a variety of reasons, and everyone has these, and you probably have a lot more, but these are just the main reasons that we see out there. We use trust to protect assets from death tax. And don't forget state taxes here, estate taxes and inheritance taxes and generation skipping taxes. And one of the things I think is sometimes difficult for us to focus on, but we have to do this when we're planners, is that just because our client happens to live in a state like Missouri, where I practice, that does not have an estate tax, it doesn't mean the children, one or more of the children, may not someday live in a state that has an estate tax. And in many cases, those states, their exemption is much smaller than the federal exemption. So, for example, 2 large states, both Illinois and New York, have an estate tax or an inheritance tax. I had one client in just the other day that had 4 children. 2 of them lived in Illinois and 2 live in New York. So it's a big issue, and we have to focus on that so that you'll trying to get the feel of that as we go through here. So don't just focus on federal exemption levels. This seminar is going to focus on state exemption levels. In Illinois, for example, where I'm also licensed and practice a lot, you can easily pay a 15% estate tax, even though there may not be any federal tax. Lawsuit protection is a big thing in our practice and in that book, Optimum Estate Planning, because my view has always been, if a client gets in a car accident and dies and potentially kills someone else in that car accident, the whole estate could get wiped out, and everything we've been doing in the way of estate planning would be moot. So we have to protect our clients from lawsuits, and as we know, trusts are one way to do that. Obviously, we all use trust to protect our minor clients, minor children, but we also know about older children, too. Just yesterday, I met with a woman. She has 3 kids, and 2 of the older children, this is the people that she wanted to protect the most. One, because he's now on his 5th marriage, and the other one, she says, is basically controlled by her spouse, and so she's very worried about that. So even though those kids are in their 50s and 60s even, she wants to be sure she used trust for them, those children. And of course, any other beneficiaries, not necessarily children, they could be other family members or friends. And obviously, divorce protection for your kids. That's a big one, I don't know, probably for you, but also for my clients. It's very important, if possible, to protect children's inheritance from divorce. And when I say remarriage protection here, I'm more worried about my client's own spouse. So the client dies, and now the spouse remarries, and we want to be sure that our assets are protected for the spouse and our own children and don't end up with a new spouse or the spouse's children. So remarriage protection is another big reason we use trust. Special needs trust, obviously, we all have clients. I have about one a week that has a special needs situation, and obviously you have to use trust there. And finally, second marriage situations. I don't know about you, but again, I would say 25 or 30% of my clients are on second marriages. So one spouse may have two children, and the other spouse may have two children. If you don't use trust in that situation and you just have everything pass outright to the spouse, you may be looking at a malpractice suit by the children. So trusts are all over the place, and again, in my practice, at least 95% of the clients at least use trust. So big deal. So this is what this topic is all about. In light of that fact that we want to use trust, what is the relevance of the higher estate tax exemption? As all of us know on this conference, trusts have high income tax rates, and so a lot of people say, well, we don't want to use trust because you just get $12,500 of income and you're in the maximum bracket. You can pay the potential 5% dividend and capital gain penalty at real low levels of income. You can pay Obamacare, Medicare tax at real low levels of income. So why would we want to use trust? And I totally agree with that. But although this seminar is not on that topic, the book I mentioned, about half the book is focused on, well, how do you avoid the high income tax rates on trust and still get all the protections I just mentioned about trust. That's kind of the focus of that book, not the focus of this program. This program is more focused on creating income tax basis when our beneficiary dies. And by that, by beneficiary, I mean either the client's spouse, the client's children, or the client's grandchildren. How can we have all the protections of a trust and still get income tax basis step up when that beneficiary dies, because most people think you don't get that. So again, that's a big focus of my book also, and it's a big focus of the course I teach at Villanova Law School. I teach income taxation of trust, and my big focus is how to minimize those high income tax rates on trust and also how to get basis step up. Okay, moving on to the next slide here. What we find in estate planning is that if new $11 million exemption, if we have clients that are above $5.5 million in estates, including life insurance and retirement benefits, we want to be sure, especially if they're over $11 million, but even over $5.5 million, we want to be sure we're getting close, both clients, $5.5 million, $11 million exemption, and the only way to do that is to make sure each client owns that much or each client's spouse owns that trust. Again, what I see all the time here is this big emphasis on, well, why are we worried about that? We have the spousal portability election. And just so you know, I've never used that as spousal portability election except for in a few cases where I want to also get the maximum advantage on IRA rollovers, et cetera, and I might use portability there because, as everyone knows, you get more deferral when you pay outright to a spouse than to a trust for a spouse. But that's about the only time. But again, most people say, yeah, but if by using portability, you get you don't have those high income tax rates on trust, and you get basis step up at the spouse's death. And my point again is, if that was a correct assumption that is the only way to get those two benefits, I would agree with all these presenters, but that's not the only way. And again, that's why we rarely use portability, because once you pick the portability route, as you see on this slide, you know, it may not be available if the spouse remarries. It's amazing how many people forget that. If the surviving spouse remarries and the new spouse dies before that spouse, portability is not even available. So basically, it's just totally a crapshoot in most situations to rely on portability. As everyone also knows, portability is not allowed. It doesn't protect future growth in the size of the estate. It's not available for generation skipping tax purposes. It may not be available for state death tax purposes. Most of the time it's not. And by the way, I didn't mention this earlier, there are at least 15 states that have some form of state inheritance or death tax. Portability eliminates asset protection, which I just emphasized. So if you just pay everything outright to the spouse, you just blew asset protection for at least half of the trust assets. And of course, portability never really makes sense in a second marriage situation because you're just allowing that spouse to transfer assets to the spouse's own children or new spouse, short of a premarital agreement. You could use an annuptial agreement on that, but as everyone knows, the difficulty on that is enforcing it. So again, the whole dilemma is, yeah, but if you don't use portability, we have these high income tax rates on trust and we lose basis step up, and that's what we're going to address now. I first want to talk about, there's two types of trusts out there, at least in my opinion, that we have to worry about. And the first type is really the simpler one. That's the one that the more common type of trust where the inclusion ratio, the generation skipping tax inclusion ratio is 0. In other words, there aren't really any estate tax issues. It wasn't a big estate, or at least this portion of the estate was not large. So the trust is not going to be subject to generation skipping tax. And so therefore, if it's not subject to generation skipping tax, then it's generally not also subject to estate tax for your typical bypass trust or a trust for a child or grandchild. So that's good, but again, the issue for most attorneys, again, let's ignore the current income tax issue. Let's just talk about stepped up basis. So the issue is, well, why would you want to use a bypass trust for the spouse if there's not going to be any basis step up when the spouse dies? Isn't that malpractice? Okay, and again, I would say yes, you're correct. It is malpractice if you couldn't solve it, because what you're doing there is just creating a tax liability that wouldn't exist otherwise. But if you can solve that issue and still protect the assets from lawsuits against the surviving spouse, remarriage issues, etc., then I think the table is flipped, and you basically could have protected it, and you still could have got basis step up, but you chose not to do it just because you thought it was simpler not to do it. And I don't think it's that is actually a good enough reason, and the book, again, emphasizes all that. Okay? So in general, this is the issue we're trying to address by the first part of this presentation. So again, this is your basic trust today, a trust with a 0 inclusion ratio, and you believe in the fact that trusts are an important thing for all the reasons we just talked about. What can we do about that? So we have to think about that, because it is true that those trusts in general get no basis step up. So if $1 million went in the bypass trust and it was worth $2 million when the spouse died, you're basically someday going to have capital gain on that $1 million of gain. And by the way, as you probably already can sense from my discussion today, we use these bypass type trusts about 80–90% of our time in our planning, regardless of whether there's an estate tax issue. And the reason is because you want to protect the assets from lawsuits against the spouse. Spouse might remarry, so you're trying to protect against remarriage rights, etc. So we do not limit these to taxable estate situations at all, because again, as you'll see, we're going to solve all these income tax issues. So what's involved in that? How can I have a bypass trust, or later on a trust for my children and grandchildren, and still get basis step up, again, in the smaller estate situation where we're not really worried about estate taxes? How can I get basis step up? Well, this is, again, discussed in the book, and it's in these articles, too, that are attached. But the whole concept is give the, and everyone's familiar with this, give the beneficiary a kind of a limited general power appointment. Usually it's just a power to appoint the creditors of the beneficiary's estate, and you only give them, as the beneficiary, a power of appointment, a general power of appointment, to the extent that it won't cause estate tax. So make it real simple. If I had a $5.5 million exemption and my spouse dies and has a $3 million independent estate, and let's just say this bypass trust is worth $4, well, we'd only give that spouse a power of appointment as to $2.5 million. That would get him or her up to the $5.5 million exemption, not pay any estate tax, but at least as to that $2.5 million of assets, we've got basis step up. And a lot of people think, well, can you do that? Can you have a partial general power of appointment? And the answer to that is yes. It's right out of the regulations. Okay, so again, the regulations are referenced in my book, but it's right out of the 24 regulations where you can have a partial general power of appointment. And so that's what we do. We're only going to give you a power of appointment, a contingent or conditional general power of appointment as to a portion of the trust, not the whole trust. If if a beneficiary, oh, I want to go back one slide here. There's blanks in these slides. Here it is. We do put an exception to this automatic rule, though, if the beneficiary has a spouse. So here we're talking about basically trust that you set up for your children, and the child has a spouse. And so you'd say, well, why wouldn't I, let's just say the child dies and has a $3 million estate. Why wouldn't we automatically want to give that child a general power of appointment as to $2.5 million to get the child up to $5.5 million, and get basis step up on that $2.5 million? Well, the reason is because we don't know the fact situation of that spouse. So let's assume that spouse has a taxable estate. So our child's spouse has a larger estate. Well, if we automatically included those assets in the child's estate to the tune of $2.5 million in my example, you've now the child will have to forego portability. So the surviving spouse of that child will not get the extra $2.5 million, which could have ended up avoiding estate tax, or at least reduce estate tax in that child's surviving spouse's estate. So again, all we're doing here with these type of trusts is we're not avoiding tax, we're just creating basis step up. But if there's a trade-off between paying 40% estate tax, okay, and creating basis step up, in every case, we're going to say we want to avoid the 40% estate tax. So, but we don't know all the facts. We have no idea who our children are going to be married to, et cetera, et cetera. So in my opinion is you don't make the allocation, you don't make the inclusion automatic in cases where the child's spouse is married. Instead, you give an independent trustee the ability to put that power of appointment in to all or partial extent. And again, we have forms on that are in that textbook. Okay, so it's a little bit complicated, but we think it's important to do that because we cannot predict this with certainty what the facts are going to be. If we have a situation where our beneficiary, our child is a beneficiary of more than one trust, we have to draft into the formula then that the power of appointment will be allocated among those trusts. So it would only be a pro rata amount based upon the value of the assets at the beneficiary's death. A little more complicated than that, and it's discussed more in the book, and there's formula language in the book about that. But we do want to be sure that we spread that out. We don't put it on one. And you'll see in the book that we generally are going to allocate that exemption, that inclusion, first to trusts that don't have a zero inclusion ratio, and we're going to go over that a little more today. So that's kind of the idea on that if you have more than one trust, typically you won't, but if you do, you might have a life insurance trust or some other kind of trust, and you want to allocate that inclusion. So again, this is all permissible under the 2040 regs, and what's also permissible under the 2040 regs is that when we decide we're only going to include part of the assets in the beneficiary estate, the question is what part? Well, you can do this also under the 2040 regs. You can say, well, if I can only include $2.5 million, let's say, of a $4 million trust, zero inclusion ratio trust in my beneficiary estate, which $2.5 million am I going to include? Well, we want to include the assets that are most highly appreciated. Okay, and the reason for that is that then we'll get the maximum for our dollar on that. We'll get the maximum basis step up by only including. So, example, if you had $2.5 million of appreciated stock and $1.5 million of bonds in the trust, let's just include the stock in the beneficiary's estate because that way we'll get full basis step up for all that stock, and bonds typically don't appreciate, and so we don't have to worry about that. And again, that's all permissible under the regulations, and the form language is in the textbook on that. But that's, I think, a very important part too. And that's in essence how you can, in most cases, get basically full basis step up, because even if you're not including the whole trust in the beneficiary's estate, you're at least including all the equities in the beneficiary's estate or appreciated real estate, et cetera. And I also think it's important that you structure the trust so that the power doesn't apply to any assets that have depreciated in value over a historical cost basis. So, because you can also have a basis step down, not just a basis step up. So you can draft that into the trust, and that's what we do. We say if the assets have actually gone down in value from their historical cost basis, we actually don't want to have a power of appointment over those assets, and based upon the last 3 or 4 days, that could have happened in a couple situations. Now, this is an important point here about one other exclusion we have in our forms, and that is that, as you might remember, President Obama was proposing basically kind of an automatic triggering capital gain event at a beneficiary's death as to assets includable in the beneficiary's estate. So again, if that ever happened, if that ever got passed, the form says, well, you don't have a power of appointment then to that extent, and the reason being because, again, all we're trying to do here is get basis step up. Well, if the cost of that is an automatic deemed gain at the beneficiary's death, we do not want that. So that's drafted into the forms too if that ever happens in the law. And I guess it could happen someday. So my view is anything that's ever been proposed out there, we need to draft for. And it's a little bit difficult, but that's why I kind of give you a head start with the forms in the book. Now, here's another situation here in that you have to envision. And there's been some talk of, well, what if they change the 1014 basis rules so that a general power of appointment no longer creates basis step-up. Remember, basis step-up is all under 1014, and a general power of appointment tax on a person's estate is just one of those ways to get basis step-up. Well, because of that, then I think you need to build into your forms, well, what if that situation occurs? And there's other ways to get basis step-up. One of them is, so the one rule we've been talking about is the mere fact that you have a power of appointment, general power of appointment causes basis inclusion. Well, they could eliminate that, but there's another one in there that says, well, you can have a power of appointment as long as you actually exercise it. Then you have basis inclusion. So in that example, the beneficiary would have to actually exercise the power to get it, but you can still get basis inclusion. You'll see what I do in my drafting is I only if I absolutely have to do I require some action by a third party after my client's death, because I just think that if you want to make everything self-effectuating if possible, because you're not going to be there, or you may not be there to make sure all these. That's why I'm not a big fan of disclaimers. I mean, you may not be there to make sure everything does everything properly, and so I'd rather, if possible, have it all self-effectuating, but in certain situations, it's just the way it is. So this would be an example. It's built into our forms, but even that may not work. So let's say they take that away. Well, then you may want to, in my opinion, in other words, they take away the exercise of power as a possibility. Then you want to, this is where you want to have clauses in your forms where you have trust protectors that can then possibly add another clause. And for example, they could change the trust, if possible, to say, well, as to all appreciated assets, they are automatically paid to the beneficiary's estate. And if you're not going to get basis step up when the assets are actually part of the beneficiary's estate, then you're never going to get basis step up. I mean, 1014 just won't even be there anymore. So, so the trust protector language that most of you have in your forms is still important because, again, we just can't predict the future on that. This is another alternative that we're going to discuss later on too, and I think it's sometimes overlooked, but again, it's very technical, and this is not a course on 2041A3 of the Internal Revenue Code, but just kind of remind everyone what that says. It says that if a person has a limited power appointment, so not a general power appointment, but so this is the spouse or the children, but they exercise it in a manner that is not tied to, that the period is not tied to the creation date of the first power. And what they have to do here is create a second power. So if you have a limited power of appointment and you exercise it by creating a second power, either in your children or whatever, and that second power can be in turn exercised in a manner that does not have to tie to the creation date, whatever that is, by the way, that's an unclear issue, but the creation date of the first power, then to the extent you do that, those assets are actually includable in your estate or in 2041, and therefore, under current law, can generate a basis step-up. So this is important, some flexibility there, and some people may like to do that. Again, I don't love doing it that way because it's requiring action by a future beneficiary, and I may not be around, but it is an alternative, and we're going to get into this more later on existing trusts. It may be your only and best alternative to get basis step-up. But it's something to look at, and again, the book discusses this more, and the articles discuss this more, but I think it's a good technique where there are no other options out there for creating basis step-up, and we've done it several times. We're doing it right now in the office on several different clients' situations, and I'm going to get into that more. So again, that's called the Delaware Tax Trap. Most of you are familiar with it, but you can read up more about it in the book and elsewhere on that. Most of the time it's worked in the past to be a disadvantage. What we're trying to do now is actually use it to our advantage. And the same deal, you can violate 2041A3 on a partial basis. You only violate it to the extent it does not cause estate tax. And again, we've done it several times. It's perfectly permissible. You just got to be careful when you're drafting. Now we're going to get into a more complicated situation, and these are, and again, it's going to be less frequent, but you're going to have some of these, where you have trusts that don't have a zero inclusion ratio. They're actually subject to generation skipping tax. So these are your higher net worth clients, and then we'll get into more existing situations later on, but your higher net worth clients, and we all wish we had more of those, but we all have some of them, and if we don't know these rules, it's going to be tricky. But let me kind of explain the concept here. Why are we even concerned about these types of trusts? Well, it's not a basis issue here, okay, because as most of you know, if you have a trust that's subject to generation skipping tax, that trust automatically gets a basis step up when the beneficiary dies. So if you have a trust with an inclusion ratio of 1, when the child dies and they pay the 40% estate tax, there is a basis step up to the grandchildren at the children's death. So that's not the issue here. The concern is this, that with these higher exemptions, okay, what's going to happen is you may have a client that has a taxable estate, but the client may have 4 kids. Well, if you divide that taxable estate by 4, maybe now you get much smaller piece per child, and one or more of those children is not going to be subject to estate tax. And we all have that. And sometimes it's going to be none of the children are going to be subject to estate tax once you split the parents' estate up among 3 or 4 kids. So that's the issue, because a lot of people forget that although we doubled the size of the estate tax and generation skipping tax exemption in the new law, we didn't change the tax on generation skipping trust. It's still a 40% tax. So if you have a trust that's subject to tax, it's still 40%. It doesn't really matter what the beneficiary's size of the beneficiary's estate is. It's going to be a 40% tax plus potential state taxes on that trust if there's a generation skipping transfer when the child dies. So that's, again, although this is a complex area, it's less frequent, it's really important, because is there a way by using powers of appointment, again, conditional partial powers of appointment, to lower that tax? And again, the obvious situation is, well, yeah, if the child's estate is only $2 million and there's $3.5 million in this trust, okay, that's all going to pay a 40% tax when the child dies. Well, if we could include that $3.5 million in the child's estate, there wouldn't have been any estate tax. Wouldn't have been any generation skipping or estate tax. So this is a big, doesn't come up as much, but it's a big dollar issue, okay? But unfortunately, it's not quite that simple, and that's the point I'm trying to make here. It's not quite that simple to say, well, why wouldn't you just automatically just include the trust in the child's estate when the child dies? Well, the reason is because it's not necessarily going to be a lower tax, and one of the main reasons is what I was mentioning before, is we cannot assume that our children are not going to end up living in Illinois, Massachusetts, New Jersey, New York, or one of these states that have an inheritance or estate tax. And so as a result of it, you had a situation, and most of them don't have generation skipping. Some do, but most don't, or it's not very large. So you have a situation where the trust would have been subject to a federal estate tax, but because you just terminated the trust or gave the beneficiary general power of appointment over the whole trust, so for example in Illinois, okay, you may have just raised that tax rate from 10%, from 40% to 50% or more by merely including the trust in. So you can't do that. It can't be that simple, unfortunately. And again, we cannot assume that where our children live today is where they're going to live when they die. Very mobile society. So we got to build that in. And the whole idea of this is to it's going to be impossible to know where the kids live. So the challenge is going to be to figure out, well, what can we do? Okay? So what we do is we develop a formula. This, by the way, is not in that book because this formula is just developed. We just developed that. It is not in that book. It will be in a newer edition of the book, but it's not in the current book. But we basically develop a formula now in our trusts that have a inclusion ratio of other than 0. We develop a formula that says basically, this is what it says. It says the beneficiary has a general power of appointment, but only to the extent that the aggregate federal and estate heritage, GST, and other transfer tax liability applicable to the trust assets are lowered at the beneficiary's death. Okay, so if they're not going to be lower, like in that Illinois situation, and they wouldn't be lower, they'd actually be higher, then you don't have a power appointment. But in a lot of cases where you or at least in a situation where the beneficiary has a taxable estate, but in most cases where the beneficiary doesn't have a taxable estate, to an extent, the tax can be lowered. Again, they might be subject to a state tax, an estate or inheritance tax, but let's say that tax is 15%, but the beneficiaries, and for example, Illinois has a $4 million exemption. So the beneficiary might have an estate of over 4 and have to pay a 15% tax, but their estate is under the 5.5 or the $11 million exemption level, so there's no federal tax. Okay, so yeah, they might have to pay a 15% tax, but that beats a 40% tax by 25%. See, so that's what we never know where kids are going to be. So all you can really do is and put a formula in there, and it sounds like, boy, this is really complicated, Mr. Blase. Yeah, but it's important. It can be a huge issue, and I think we have to learn how to explain it. So yeah, it's basically a simultaneous equation. It might be some work actually figuring out what the amount is includable, but I really don't think the formula is really that difficult, and you basically have the language right there, right here on this slide. Okay? Now, here's where it gets, now I'm going to give a little fine-tuning here, and you can read this at your leisure because it does get pretty technical, but then now you're saying, okay, well, if we're only going to include part of it, which assets do we include? And here I'm saying you actually want the ones with the lowest amount of built-in gain, which is the opposite of a situation where there's a zero inclusion ratio. And the reason for that is the things I just told you about is the law somehow gets changed, and so that it doesn't mean you don't include them, but you include these assets last. And that's because the law does get changed, and there's some kind of a built-in gains tax or whatever when something is includable in a beneficiary's estate but not in a GST trust. You might want to say, well, those ought to be the last assets we include, because although we're going to save tax, we could save more tax if we included those assets last. And again, we're getting pretty technical here, but I think you might as well put it in the formula, and that's my view. And another thing too is we say, well, in this formula, and you're saying, okay, include assets in the estate to the extent it will lower overall taxes. Well, you got to have assumptions in there because you don't really know what the number is. So we assume that there'll be, this is the last part of the slide, you assume that there are no deductible administration expenses, there's no qualified disclaimers, no alternate valuation date. So you basically have the worst case assumptions in there. So you may not be fully using the person's available exemption, but you're using most of it. But you got to make these assumptions because otherwise you never know what the number is. It has to be a certain number on date of death, and that's how you do that, by basically making those assumptions that there are no alternate valuation date elections, no administration expenses, no deductible administration expenses for estate tax purposes, no qualified disclaimers. Okay? Again, getting a little technical, but that's what you got to put in the document. The other thing I want to mention is that if you have a situation where there's the liability, the tax liability will be the same. So you're in English, this is a real high net worth situation where you have a 40% GST tax, but the beneficiary is also in the 40% tax bracket. And you say, well, there really is no change, so why do it? Why include it? You actually should, in most cases, go ahead and include it, and this is what our formula does. And the reason for that is that the benefit of including the assets in the beneficiary's estate anyway, even though there's no direct, immediate tax savings, is that it shifts the transfer down a generation. So now the assets are includable in the child's estate, so therefore we're starting the generation skipping assignments all over again on that, and that could be save tax down the road. It also potentially qualifies you for the prior transfer credit under Section 2013, and this can happen. We just had one, and sometimes this is relevant too in a spouse situation. But again, we're getting pretty technical on that. But I'm just saying that I think that our view is that even if there's no savings, you're still better off including it in for other potential reasons that will be more relevant down the road. Now let's get into the spouse situation. And again, we're talking about inclusion ratio trust, not zero inclusion ratio trust. And again, here the rule is kind of the opposite of what we said before. And here's why. Here where we say we are going to have the inclusion unless an independent trustee says no. And you'd say, well, why is it the opposite of the zero? Well, because in this situation where you're talking about a certain 40% tax. Okay. Now, the tax will be immediate, and it's a 40% tax. If there's $2.5 million of portability exemption available there, we would rather include that trust in that beneficiary's estate, even though the beneficiary has a spouse. And the reason is because you just avoided 40% tax on $2.5 million. You just avoided it immediately. Okay. It may be that, or you may have pushed it off to another generation, or you may have just completely avoided it. So our view is that almost every client, that's why you have the exception there if the independent trustee says otherwise, but 99% of the cases, most clients are going to say, I would much rather save the immediate 40% tax and worry about portability issues later. The reason the other one's different and you treat it differently is there you're not saving any tax. All you're doing is creating basis step-up. Here you're actually saving at least a 40% tax plus state tax. Again, kind of technical, but I think it's important that we kind of reverse the presumption for trusts that have an inclusion ratio other than 0. Okay, now if there's actually, this is going to be rare, but it is possible that you could have a situation where there's no GST tax even though there's an inclusion ratio of 1. And the reason would be, let's say they repeal the generation skipping tax. It might be an example. Then you basically fall back to our forms basically then assume it's a trust with an inclusion ratio of 0. And the reason being that we'd still want to potentially have inclusion for basis reasons. Okay, it's not going to save any state tax, but it may save basis. So we build that in there too. Again, very unlikely situation, but it's certainly possible that down the road we could have a situation where there's, because that was basically the proposal in the House. That's what the House bill passed, where there'd be no GST tax or estate tax, but there was still going to be basis step up. So worth doing that in that form. Again, going to be kind of rare, but we got to build it in the forms just in case. All right, now, very important topic, and fortunately we're actually ahead of schedule, so that's good. We're going to have plenty of time for questions. I'm trying to time this basically about 3 minutes per slide, 2 to 3 minutes per slide. But this gets more complicated, but it's really important, okay? What about, what we've been talking about up to now is drafting, but what about all our clients that have existing trust? Okay, so there's an existing bypass trust, or there's an existing lifetime or other trust for children, and there may be estate tax issues, there may be basis issues. Is there anything we can do about it? Okay, and it gets more complicated, but it's very important, and it can actually be an important part of your practice. What we did was we basically made up a list. We're not done yet, but we made up a list where all these situations for our clients exist out there, and then we basically have a spreadsheet, and we decide which approach our approach would be available and which would be the best for the particular situation. So again, these can be insurance trusts too, existing ILETs where our client isn't even dead yet, okay? But there is an irrevocable trust, okay? What can we do about that? But more, we're also talking about situations where either a spouse is a beneficiary of a bypass trust or a child is a beneficiary of a potential generation skipping trust. Is there any way we can get basis step up in those? Because as we just talked about, the general rule is no, you don't get any basis step up. And short of just terminating the trust, assuming we could even terminate it, we're going to get into that. So the first slide here is the state decanting statutes. To be honest with you, I haven't even kept up. I don't even know how many states have decanting laws today, but I'd imagine most of them now have it. We have one in Missouri, and we had it fairly early on. So the issue is, can we, and again, this is not a course on decanting, but if your state has a decanting trust legislation, can we basically decant and move the assets to a trust that would be includable? For example, one that has a conditional power to appoint the creditors of the beneficiary's estate. Okay, so again, what we're talking about here is, and we're going to talk about kind of going back and forth, but we're talking about trusts, not only ones with 0 inclusion ratios, but also trusts that they're actually subject to generation skipping tax, but the way they're working, there's going to be this automatic 40% tax. Is there a way we can insert this formula into those trusts to basically potentially avoid or minimize that generation skipping tax? Again, not that it comes up that much, but it's a major issue, and I think we need to look at all of our client situations. And as you're going to see, there are actually several good options out there. It's not like it's impossible. It's very technical, and you got to be careful. But again, this is discussed in my article, the first article that follows the PowerPoint materials. Okay, but basically, when it comes to state decanting statutes, it largely depends upon the terms of the document as well as the terms of the state decanting law. And I can tell you that some of these laws are very difficult to read. There's a lot, in my opinion, they're vague and ambiguous, but if you really spend a lot of time with it, you can eventually figure out what they mean most of the time just by kind of piecing things together. Most of them are drafted in states that have the Uniform Trust Code, so definition of terms that are used in that statute are really important. So you can't just look at the decanting statute, you got to look back at your Uniform Trust Code and what do these various terms mean. And one of them, probably the most important term to me, is the definition of the term beneficiary. And again, you typically won't see that in the decanting statute, but it is in your Uniform Trust Code, and it's very important. And one other thing I would tell you here is that I had to actually, to get the answer to a lot of these questions in Missouri, I had to actually revert to the commentary of the Uniform Trust Code, and then the answers became clear, but they were not clear on the face of the Missouri statute. I had to actually look at the commentary and the explanation to figure out some things that were in the Missouri law. So again, difficult definitely, but very beneficial, and I think it's really worth it. So let's talk a little bit about the decanting law. In Missouri, this is my own opinion, I don't think you can use decanting to accomplish what you want, and that is because the Missouri statute rather clearly states that you cannot add, it does state that you cannot add beneficiaries to a trust. So the new trust number 2, cannot have beneficiaries that are different than, or at least additional to the beneficiaries in the first trust. Well, you'd say, well, where are the additional beneficiaries? All you did was add a power to appoint to creditors of the beneficiary's estate. Well, our reading, again, in conjunction with the commentary in the Uniform Trust Code, the commentary, the definitions in the Missouri law of the term beneficiary, the definition definitely includes the term contingent beneficiary. So a beneficiary includes a contingent beneficiary. So what is a contingent beneficiary? Well, I can tell you again from reading the Uniform Trust Code and the commentary, it does include a potential taker under a limited power of appointment, or even a general power of appointment. Any potential taker under power of appointment is a beneficiary of a trust. May not be what's called a qualified beneficiary for other purposes of Missouri law, other purposes of the trust code, but is a beneficiary. So if you put that in there, you added beneficiaries, and that's not permissible. So I don't think you can even use decanting. There's other reasons too, more technical reasons under Missouri law why you probably can't use it, but to me this is kind of a clear one, and you'll have to look at your own state's law to see if you can do that. This is my own opinion that I think actually that was a good answer. And you say, well, why is that a good answer? You can't use decanting. Well, if you think about it logically, if the decanting statute permitted a trustee to do this, to just transfer the assets to a trust, which gave that beneficiary a power to appoint to his or her the creditors of his or her estate, just think about that a little bit. In most cases, you could potentially have an automatic general power of appointment on every trust you've ever set up that was intended to be exempt from estate tax, including bypass trusts. Every one of them could potentially be automatically subject to 2041, because if you name the spouse or the child as the beneficiary of the trust, and as trustee that child had an ability to transfer to an assets to a trust, which had power to appoint to creditors of that person's estate, that's potentially a general power of appointment, because if you read the law, it says it doesn't really matter what capacity you have that power in, trustee or otherwise, it's still a power. So I think that this is actually a good resolution, but I will tell you, it wasn't right on the face of the Missouri statute. You had to kind of dig hard to figure out that answer. So I was actually very happy to get that answer. I'd rather explore other ways to get where we want to go to. So here's some other ways. If you have a trust protector clause in your trust document, most people have those today, and they're typically drafted so that an independent trustee can modify the trust to create tax advantages. That may be a way to go. And so take a look at your trust and see if it has it in there. Of course, you got to comply with the terms of the trust protector. Just because there's a trust protector clause doesn't mean that your trust is the terms of that come right within what we're trying to do today, but you can at least take a look at that, and in many situations that's going to be out there. Of course, most older trusts don't have these type of trust protector clauses in them, so that's not going to be the answer, but that's something to look at. Another thing is like Missouri, for example, has a trust modification statute where you can actually go into court and modify the trust to achieve tax advantages. So that's a much more expensive route, and you may have to get a lot more consents, et cetera, to get that done. But if there's enough gain or there's enough estate tax savings involved in there, it may merit doing that. And in any event, at a minimum, we have to show our clients that we presented them these alternatives, because with the lack of privity out there, we don't want children later on or grandchildren suing us because we didn't even present this as an option to our client. So that's out there in a lot of states today. Some of them require court approval, some don't. An important point, and this is a tricky area, and that is that let's say you are in a state and one of these options is available to you. You got to be really careful, though, just because an option's out there available to you, it could create other tax consequences that you weren't thinking about. So be really careful on that you don't create potential gift tax issues, generation skipping tax issues again, and those are discussed in the article. Those are also discussed in my book, but it's a real tricky area, so you got to be careful, but you got to think it through. What are we doing here? And basically, if for example, a child goes along with changing a limited power in a trust, the spouse has a limited power, and child goes along with changing it to a general power to also appoint to creditors of the spouse's estate, the issue would be, well, has that child made a gift? Because now what you just did was you told that spouse, hey, you can basically appoint to yourself because you can appoint to creditors of your estate, and so have I given up rights? Well, in our opinion, no, you haven't. That's the big advantage, because if there was a limited power in there, remember, you don't have any rights. You have from a gift tax standpoint, you have no rights, because that spouse could have appointed it all to another child, could have appointed it to a grandchild, et cetera. You're not giving up any legal rights if you go in and sign off on a deal that says the spouse now has the power to appoint to his or her creditors of her estate. I don't think that's a gift or a generation skipping tax issue, but you can think it through yourself. In my opinion, you don't. But that's if there is a power appointment in there. Okay? If instead, though, you're just a remainder person and there is no power appointment, so you are entitled to the assets, and you go in there and say, I'm going to give my parent a power to appoint to his or her creditors of her estate, that's a potential gift by you, okay, because you had a vested remainder and you just basically potentially took it away from you. So that's, and then maybe a gift may not be. It may be a gift to someone that you could argue, well, it's impossible to value it, therefore it's not a gift. The IRS would argue, well, because it's impossible value, then it's a complete gift because the spouse has full control over it. So this is an issue. So you got to be careful on that. If it's going to involve any kind of consents on the part of beneficiaries, and most of the time the trustee is going to want consents, you have a potential gift and generation skipping issue. I think it drops out, though, in trust, which basically every one of our trusts has a power of appointment in it, except if we're intentionally trying to exclude the power of appointment, limited power of appointment. Then, again, you have to pay attention to that issue. Again, we're just kind of discussing it more here, this whole limited power of appointment issue. I think that one of the options you're going to see, too, in limited powers of appointment is that if you can't go under one of the other rules that we discussed above, remember what we talked about in the first part of the program about intentionally violating 2041A3. Well, if a person has a limited power of appointment and these other options aren't available to you, or you feel like they may create gift or estate tax issues, what you can do, and we've done this several times, is you have the beneficiary actually exercise the power of appointment and intentionally violate 2041A3, only to the extent that it doesn't cause any estate tax, though. Okay, so you may save generation skipping taxes on that deal. You may get basis step up on that deal, but you carefully craft the exercise, again, under the regulations 2041A that says you can have a partial general power of appointment over a trust, and you carefully craft it so that you're only violating 2041A3 to the extent that it won't cause estate taxes. And Again, this is probably going to be your biggest one. This is my opinion, your most available option. Obviously, the option is not available if your spouse or beneficiary does not have a power of appointment. But if they do, this is one that you can, as long as this is in the code, you can go ahead and intentionally violate this rule. Got to be really careful in your drafting, but intentionally violate this rule to the extent it won't cause any federal, and don't forget estate or inheritance tax liability. And again, this is probably the one we're using the most for our older trusts that don't have trust protector clauses in them. Okay, we're using that because I think that's easier than, and it has less gift and estate tax issues than kind of going the court route and trying to modify the terms of the trust. And again, as we've already mentioned, at least in Missouri, I don't know about other states, that you can't even do this type of a thing via the state's decanting legislation. Again, the way we do this stuff is we try to use formulas in what we do when you exercise these powers. And I think it's important, though, when you do that, is that you got to remember that rules can change. So, for example, I mentioned this at the outset. Even if you could do it with a trust protector or a trust modifying statute, I would not recommend just terminating the trust and distributing outright to the beneficiary. Okay, just to get basis step up or just to get the estate tax inclusion. And the reason for that is, again, federal estate tax exemptions could change. A child can move, even a spouse can move to a different state. You've exposed the assets to protect potential lawsuits, et cetera. So I'm not recommending terminating these trusts. I'm recommending amending them, quote unquote, amending them under these different rules to put in basically this formula type language that's only going to have inclusion to the extent it creates an overall tax benefit for the trust. So kind of just be careful on that one, because if you just go in and terminate it later on and that beneficiary got sued and then there's a claim against you because you didn't need to terminate it to get to the same result, that would be a malpractice lawsuit. All right, now we're going to switch gears, and again, you can ask any questions on that first topic, and we'll try to answer those at the end of the program. But now I want to spend a few minutes on another topic, and I actually have two articles attached on this clawback topic. And again, it's only relevant for larger estates, but you're going to have some, and you need to be aware of the rules and not get trapped by them. Again, my view is always, as long as you really know the rules and you know the different planning options, as long as you clearly present those to the client and you can document that, if one of these bad things happened, well, at least you did your best you could. So let's talk about this clawback topic again. By the way, I just got a call the other day from New York Times, and they interviewed me on this. I think they're going to run an article on this, but I even told them the same thing. I go, well, it affects so few people. But I think they were just interested by it because it's a very interesting topic. So again, remember at the very beginning of the program, I said, what's my goal today? It's not to tell you that the exemption temporarily doubles. It's like, what's the relevance of that? Well, we just talked about the relevance of the higher exemption. Now we're going to talk about the relevance of the temporary aspect to this. And again, almost everyone on this speaker presentation is familiar with 5 years ago when we had something like that where the exemption temporarily went to $5 million, then it was supposed to go back to $1 million. We even had $3.5 million in there for a while. So the issue was, if I made a $5 million gift today and then the exemption went back to $1 million by the time I died, what are the consequences of that? And the worry was that basically only $1 million exemption will end up getting applied to that gift. And so that was the concern. There were, you can see in my first article, there were congressional attempts to change that, to make that clear. And it's hard to read the statute, and you can read my first article on this, but the congressional attempts seemed to do that, but there were a lot of ambiguities in it, and there's a lot of issues in here, and we're going to get into them, but it's not really that simple, just saying either or. It gets more complicated. And you're going to see, and we're going to talk about it, and that's why I feel like Congress chose to kind of punt on this issue, because it's so complex and there's so many issues that, it's difficult enough for the IRS to figure out a solution. I don't really think many of our senators or our reps can actually figure this complex tax issue out, but I'm going to at least try to explain what I think is the most important part of that. And that is that I think that this clawback issue should not be an issue based upon what Congress just passed, not just based upon what I think, just based upon what Congress just passed in 2017. So again, the clawback issue, let's take the example of, this is what I explained to the New York Times, just take this simple example because it's very complicated, and a New York Times reporter, it's hard enough for us to understand how 2001B and 2010 all work together when there's gifts, but we can, but it's not easy, and it's very difficult for a person, the general public, to understand this issue. So anyway, I'm just kind of going over it again. As you know, under 2001B, how was our state tax computed? Well, it starts off, you figure out the gross tax on the taxable estate plus adjusted taxable gifts. So let's take an example of a person, make it real simple. A person has $11 million of assets, gives them all away in 2018. And they have nothing left. And now they die in year 2026, and we have the exemptions gone back down to $5.5 million. Let's just take that simple example. So, the person thinks that, well, I gave $11 million away. There was $11 million gift exemption. I have nothing left. Therefore, I pay no tax. And here comes the clawback issue. So the issue is the way that tax is computed. You first compute the tax, the tentative tax, on the adjusted taxable gifts and the taxable estate, and then you subtract out the tax on the adjusted taxable gifts, basically using date of death rates. And so right now those rates would basically be the same. It's 40%, 40%, okay? So that's not an issue. It was an issue before, as you know, when they kept changing the rates, 45, 35, 40. But now it's really not an issue for current planning, but it could be in the future. So anyway, that's how it's done. You figure out the tentative tax on the gross estate plus adjusted taxable gifts. You then take off the tax on the adjusted taxable gifts. Why are we doing this way? Because theoretically, that figures out our tax bracket. Okay, we want to add back those gifts just to figure out what bracket you're in. No other purpose, because you can see you're computing a tax on the gifts, but then you're backing out the tax on the gifts. So you're really not taxing the gifts. Okay, on a 2001B, you're not taxing gifts. They're just part of the equation to figure out what tax bracket you're in. Okay, and that's how that's done. And then you come up with this tentative tax, and then under 2010 of the code is where you actually get your estate tax credit for the exemption amount in effect at death. So, simple example again: if you had an $11 million estate, the tax on that's $4.4 million. Okay, about at 40%. The question is under 2001B2, what amount do we reduce that tax by? When we figure out the tax on the adjusted taxable gifts, do we assume the exemption in effect at the time of the gifts or the exemption in effect at the time of death? So that's, what do you reduce it by? What's the reduction on the 2001B2? Well, if you assume the the exemption in effect at the time of the gift, the reduction would be zero, because there would have been no tax on that yet. So therefore, you have $4.4 million under B1. Your offset on B2 is zero. So therefore, your tax on that in that example is $4.4 million. Okay. You then reduce that by the credit under 2010 of about $2.2 million, and you come up with a tax of about $2.2 million owed. So even though you gave away your entire estate when the exemption was $11 million, theoretically, if you use this approach of using the offset, when you figure out the offset, you use the exemption effect at the time of the gift, you're going to end up technically owing $2.2 million of tax, even though you had nothing in your estate. If instead, though, you use the exemption in effect at the time of death for 2001B2 offset purposes, well, the tax on $11 million, if you assume only a $5.5 million exemption, the tax is about $2.2 million. So now 2001B1, the tax is $4.4 million. Just you subtract out the B2 offset of $2.2 million, leaves you with about $2.2 million. You then subtract the 2010 credit of about $2.2 million, and you pay zero. Okay, so the issue is, which one do you use? The exemption effective time of gift or the exemption in effective time of death? That's the clawback issue. Okay, and again, I went through that quickly, but you guys remember this from 5 years ago. Well, here's my analysis and why I feel like it should not be an issue. If you look at the legislative history to the 2017 Tax Act, and of course there's not much, but if you look at it, it's basically the conference committee report, right? And in that conference committee report, what it says is, what's the intent when the IRS and Congress, said, we don't want to have to figure this out. We want the IRS to figure this out. So basically they say, IRS, you got to figure out how to handle this issue. But it does say, but in doing that, what you're supposed to do is carry out the Section 2001. And then what the legislative history says is, it goes on, it says, carry out the purpose of 2001. Okay, not just carry out 2001, because that's a little bit ambiguous. But once the legislative history says the intent is to carry out the purpose of 2001, well, now we at least got something. Okay, because that's what IRS you're supposed to do. So as everyone knows, when the IRS issues regulations, they just can't write whatever they want. They can only issue regulations which were in the scope of their authority, their grant of authority by Congress. Okay, and the scope here is to carry out the purpose of 2001. Well, so I looked around and said, well, what's the purpose of 2001? And I looked at different tax acts and went all the way back to the origin of 2001. Really couldn't find anything that ever said, what is the purpose of 2001? So when I wrote the first article, I said, well, at this point, I don't know what the purpose is, so we don't know the answer. Okay, that's what I wrote in the first part of the article, but I said to be continued at the very end of the article. Then I did some more analysis, and finally I figured this out. And again, there's nothing that ever says the purpose is, but you can just figure it out for yourself. Okay, and how do you figure it out for yourself? Okay, take a look at 2001 of the code. I thought, well, I don't want to take a look at 2001 of the code, okay, because that's what it's supposed to do. It's supposed to carry out the purpose of 2001. Well, what's the very first sentence of 2001? Okay, it says, a tax is hereby imposed on the transfer of the taxable estate of every decedent who is a citizen or resident of the United States. So that's pretty much, that's the purpose of 2001. To impose a tax on the transfer of the taxable estate of every decedent who is a citizen or resident of the United States. I mean, I don't know how that can be any clearer. That's the purpose, the very first sentence. Taxable estates. Well, what is your taxable estate? Well, you got to go to Section 2051. We very rarely look at this section, but a taxable estate is actually defined in 2051, and it says that in order for an asset to be part of your taxable estate, it must first be part of your gross estate. So your taxable estate is basically your gross estate less all deductible expenses. What don't you see mentioned anywhere in those first two sections? You never see you mention lifetime gifts. Okay, the purpose is to tax your taxable estate. There's nothing in there about taxing lifetime gifts. Remember, Congress said carry out the purpose of 2001. It didn't say carry out the purposes of the Internal Revenue Code or carry out the purposes of Chapter 11, 12, 13. It didn't say that. To carry out the purpose of this section only. Well, this section only deals only with figuring out the tax on a taxable estate. Gifts are not part of your taxable estate. People think they are. They think, well, yeah, that's part of my taxable estate because it's right in 2001B, and you just talked about adjusted taxable gifts. But remember what I said there was, if you actually look at 2001B, Congress is not taxing adjusted taxable gifts, because they're figuring out the tax on the gift and then they're backing out the tax on the gift. Okay, all they're doing is they're using those numbers to figure out what tax bracket you're in. Again, not largely relevant today, but it has been relevant in the past. So that's what they mention the word adjusted taxable gifts is merely to figure out what bracket you're in. Nowhere does it actually tax the adjusted taxable gifts because remember it's putting in and it's taking it out. Okay, that's kind of the issue here. But if you think about it, if you use, when in the 2001 B2 offset, if you think about it, and you say, well, what exemption did we use in this example of the 2026 death? Well, if you use the exemption in effect at the time of the gift, that's what you picked. If that's what the IRS picks, then what you effectively did was you taxed that gift. Okay, because remember what ends up happening, there's going to be about a $2.2 million tax on that gift. Okay, so in essence, you tax that gift, but 2001, the purpose of it doesn't mention taxing lifetime gifts. Not even mentioned anywhere in 2001. Okay, so you're taxing a lifetime gift, but that's not the purpose of 2001 as stated by the very first sentence of the statute. I think that is crystal clear. That is my opinion, but I think that's crystal clear that if you don't take the interpretation to use as the 2001 B2 offset, the exemption in effect at death versus lifetime, then you have effectively taxed those lifetime gifts, and that is not within the scope of the purposes of 2001. So what I'm trying to say in that is that I think that if Congress does issue regulations, okay, that don't effectively give dollar for dollar benefit to that lifetime gift, I think that those regulations are subject to being challenged as overreaching. Okay, and what I wanted to do by those articles was make sure everyone was aware of that, including the IRS. Be careful when you issue those regulations, because if you do it that way, it's going to be challenged because it does not carry out the purpose of 2001. And again, to me, that was one situation where the legislative history was clear. This is just more examples of how that works here, okay? So there could be a significant benefit for these lifetime gifts. The problem is, I'm going to refer to this one more time, the problem with this approach, though, and this is why I think Congress, remember I said there's some complexities here, why I think Congress deferred to the IRS on this rather than attempt to grapple the issue itself. So what I've been talking about so far is pretty clear. It makes sense. But what about the person that makes a gift of, he only makes a gift of $5.5 million or less, like people were doing 5 years ago. All they did was make the $5 million gift. Well, if you actually run all the math on this, and even if you use the exemption in effect at the time of death, what you'll find out is the person that made a $5.5 million smaller gift gets no benefit. It gets benefit in the fact that the growth is out of the estate, but gets no actual benefit like the person giving the $11 million. So an example, and again, this is in the articles, if I have in each case, I have a person with an $11 million estate, and the one, if he gives $11 million away, he gets complete benefit for that gift, in my opinion, and pays no estate tax. But if the same person who has an $11 million estate just gives away $5.5 million away, they don't get any benefit for that gift. They effectively don't. Again, you have to run through all the math, and it's all in these articles that I've attached, but they effectively get no benefit for that. Well, that doesn't seem fair. What I wrote in my article was, well, who said Congress was ever, and the code was ever supposed to be fair? But I do think it's an issue. And so I do think that this is one of the reasons why Congress said, we don't know what to do here. We know we want to carry out the purposes of 2001, but how to best do that, we really don't know, because it's not quite that simple, so we're going to have the IRS do that. This is my opinion of what's going on here, so just be aware of that. And I think that's relevant in the planning. I'm going to get into that a little bit here. So again, these two examples can explain, at least to me, they illustrate why I think it's not quite a simple issue of just saying issue regulations that are that carry out certain things, and then they end up have to come back 2 years later and change the regulations again. The IRS is going to have to deal with this issue. We hope, though, that the IRS deals with this issue sooner than later. So one other point, in addition to the potential overreaching argument, don't forget that when the gifts are still, this is important. I don't want to see people not making gifts because, oh gosh, until the IRS issues regulations, when's that going to be? Especially when are they going to be final? Oh, we're just frozen and now we can't do anything. All I'm trying to present here is that I really feel like you should be confident that they're not going to be issue regulations. So, in other words, to defer for your larger estate clients, to defer a large gift until these regulations are finalized. And remember, too, that who knows what could happen in 3 years if we get a different administration. We don't know for sure. We're not guaranteed 2026. But in any event, by just waiting around and saying, let's see what happens with these regulations. And in the meantime, clients could die. We could have got a lot of growth out of our estate. Again, even now when the market came back, maybe it's a good time to transfer, get all that growth out. The other thing to remember too, again, is if you're of clients in a state that has a state inheritance tax, you can be getting avoiding tax on all that estate tax too. And so I don't think we should be basically foregoing doing any planning at the same time. I think that the potential of these large gifts is still there. And we worry, too, about incapacity, other issues. I think most people read the Powell case, tax court case in Powell, and I think you got to be careful of doing everything under a power of attorney and stuff like that. So your client could become incapacitated, and now you kind of increase issues, I think. So I don't think, for my clients at least, we're not going to hold off making gifts merely because of that reason. Okay? And I finished a little bit early, so I can talk more about any of these issues if people want, or take questions. What I'd like to do is let's take questions first, and then I can do some more explanation depending on how many questions we have. Do we have any questions, moderators?
We do. Thank you for an excellent. Let me just move this one second. Thanks for an excellent presentation so far. Just a brief announcement before we get started with questions. New York State requires that you record and report the following code in order to obtain CLE credits for the live or recorded versions of this CLE webinar. If you will be requesting CLE credits for this seminar, please write this code down now. The code is TLEDXA. That's T as in Tango, L as in Lima, E as in Echo, D as in Delta, X as in X-ray, and A as in Alpha. Again, the full code is TLEDXA. Now we'll move on to our live question and answer sessions. Listeners can ask our speaker any questions relevant to today's topic in a number of ways. First, you may email your questions to estateplan@straffordpub.com. You can submit your questions by typing your question into the Q&A box in the lower left corner of your screen and clicking send. And you can also ask your questions by phone. To do so, press *1 on your touch-tone phone. Again, that's *1 on your phone. If for any reason you decide not to ask your question, simply press *1 again to exit the queue. After you press *1 and when it's your turn, the operator will announce you by first name and city for the person registered at your location. If you would like to identify yourself further, please do so. If you're asking questions by phone, please remember to turn off the sound on your desktop or we will hear an echo. Looking now, it looks like we have no telephone callers, so we will move over to our written-in questions. The first one says, is your checklist included in your book?
My checklist, I'm not sure. Everything we discussed today is in there and more, including the forms. The only thing that are in the forms that's not in there, again, is a grader in the forms is the forms for the part 2 of this seminar on planning with trusts that have an inclusion ratio of other than 0. That's not in there. It will be in the updated edition, but it's not in right now. I think that's the question.
All right, our second question says, any problem with reserving a contingent GPOA in the settler of an anti-vivos irrevocable trust?
Irrevocable? Irrevocable.
Irrevocable.
No, I mean, I think, no, it depends. If you're saying a power appointment in the grantor, okay, I think that's a tricky one, and I've written about that. Some of those articles are on my website. I think that's a trickier one, and then I tend to try to stay away from those. But there's things that can be done on that, and again, it's in my book. And part of that is there's a discussion in my book about how to create basis step up. And it's not in this article because it's relevant no matter what, but how to create basis step up at the first death of two spouses. So as most people know, when the first spouse dies in a community property state, there's basically full basis step up on all community property. The book gets into how can you create full basis step up when you don't live in a community property state. So you live in Missouri, Illinois, New York, etc. And that is, I think that's what the caller's referring to, and that is discussed in the book. And I do believe you can do that. A little tricky, but I think you can do that. And in my opinion, it's clear you can. Until they change you'll see in the book, until they change the IRS regulations, which are right on point, I think it can be done. Now, just so you know, I don't do it the same way other people do. So there's a lot of other articles and presentations out there about how to create basis step up. My way is not the way other people do. I think it's just a different approach. It's a technical approach based upon the regulations.
All right. The next question says, in layman's terms, can you explain what a zero inclusion trust is and what basic terms make it a zero inclusion trust?
Yeah, that's a really good question because that's a zero inclusion ratio trust is basically one where a person dies, or it can happen during lifetime too, but typically a person dies and their estate is under $5.5 million. Okay, and so they or $11 million today, but let's assume $5.5 million, the old law. If your estate is smaller, so most clients, this is your estate. Whenever you leave assets in a trust, whether it's for your spouse or your children, those trusts are zero inclusion ratio, which just means in English that those trusts will never be subject to tax at the next generation or potentially even future generations. So asset could stay in trust for my spouse and then could go in trust for my children and then pass to my grandchildren. And when my children die, there is no tax on that trust, even if the trust is then worth $30 million. There's no tax on it. As long as it started off when I died, there was no more than $5.5 million in it, or again, right now, $11 million. So that's a good question. So that's 95% of our clients are under those exemptions. So the first part of the article about creating income tax basis step up on those is probably the most important part. And I was just trying to make the point though, yeah, but we all have some clients that are over that exemption amount, and that can even be a bigger issue in those situations because now we're talking about not just creating basis step up, but potentially saving a 40% estate tax on those trusts. But very good question. And again, that's 90% plus of our trust are zero inclusion ratio trust. Your basic trust for a spouse or children.
Excellent. The same caller wanted to know, is there a good resource for forms of trusts and wills that address the topics you have discussed today?
Yeah, my book does. And again, what I charge on that book is the minimum. Amazon has a minimum price, and I think it was $12.95. Whatever the minimum price is all I charge, and those forms are in there. And again, I just want to alert you to the fact that those apply to zero inclusion ratio trust. I do not have forms yet in there on the second article that I wrote today about dealing with estate tax situations. But it's not. You can see though. You can almost piece it together yourself because just look at all I really did was add in that formula that I say that in addition, you also the way the first formula works for a zero inclusion ratio trust. It says only include assets in the estate to the extent it won't cause estate tax. That's pretty simple. The second formula, where you have taxable trust, is saying, well, not only that, let's also include it to the extent we might lower the overall tax. And it is today with these much higher estate tax exemptions, but we still have a 40% generation skipping tax rate on non-zero inclusion ratio trusts. You can actually, in most cases, you're going to be able to lower that. You're going to be able to eliminate all or part of that 40% generation skipping tax when a child dies. And so that's all it's really saying is not only automatically include it if it doesn't create tax. I'm saying that, but if the overall effect, okay, is to lower tax by to the extent you include it, we want to have that too under these new laws.
Excellent. It looks like our last question for now says, can you give me the name of your book again and where you can buy it, which you might have just answered half of that, but the name.
It's called Optimum Estate Planning, and you can buy it on Amazon.com. And if I have a couple more minutes here, I want to talk about the other major part of the book, and if we have no more questions, because we might as well do it, and it's a big part of the book, and it's a big part of planning. It wasn't the topic of this course, but it's related to it. If we have no more questions.
Yeah, we do have a few more minutes. Go ahead.
Okay. Well, what we were talking about earlier was that the second issue, that the reason people don't use trust or they try to minimize use of trust, is that trusts get taxed at a high income tax rate. I think right now it's $12,500 of income. You're going to be paying, it was 39.6, I think it's 37 point whatever right now is the rate. And then you have to pay, once you get over at that same level, you're paying the Obamacare Medicare tax of 3.8% tax. You also, once you have over $12,500 of income in a trust, you're paying 5%, potential 5% dividend, but I call it a penalty, a 5% higher rate, and you're also paying a 5% higher capital gain rate. And so the purpose of the book is to explain, well, if that's all you knew, if that's all you'd say, well, why would I'd want to minimize use of trust because my kids aren't going to be, because today the way it works is for a single individual, you have to have over $500,000 of taxable income to be in the highest rate. Okay, and you get with that, as you know, you get a $12,000 standard deduction that goes along with that. So very few of our children or spouses are paying tax at a higher rate. But basically, every trust is. And just to kind of go over the background for the younger people in the audience, this law got put in back in 1986, and when I was a young pup, I graduated from NYU in '82. The big thing down at Miami, or now it's the Orlando Heckerling Estate Planning Institute, the big thing was, well, because trusts at that point were taxed like individuals, on these high net worth families, well, we won't just set up one trust for little Johnny, we'll set up 10 trusts for Johnny. And so we get 10 runs up the bracket, which today would be a $500,000 level, 10 runs up that, and we're going to end up paying almost no income tax on these trusts. Well, so Congress didn't, obviously the IRS, didn't like this, and in 1984 put in the multiple trust rule, which is actually in the law right now. It's still in the law, and people got to remember this is still in the law. And it basically says if you set up multiple trusts for little Johnny, we're going to aggregate those trusts for purposes of figuring out your tax bracket, okay? Unless, but this was the problem, the ABA got an unless in there, and the unless is unless there was not a tax avoidance purpose for that. So the problem with that law in 1984 was that so people were setting up trusts. Well, this trust is for Johnny's education, and this trust is for Johnny's health care, this trust is for Johnny's retirement, and say, well, there's a non-tax purpose for it, so we get all these runs up the bracket. Now, what Congress could have done, and this is what I would have done, was I just would have said, what does it matter what the purpose is? I would have said, if you set up more than one trust for little Johnny, we're just going to aggregate those trusts for purposes of figuring out your bracket, and why should it matter what your purpose is? We're just going to aggregate them. But that's not what they did. They included in that tax avoidance purpose loophole. So as a result, if you're at the IRS, obviously you're thinking, it's going to cost us way more, to litigate all these issues than we're going to get in taxes. So what they did was, you can see this all happened pretty quickly. Then just 2 years later, they go back to Congress and they said, we're going to, they explained their plight, and rather than figure out the solution that I just mentioned, they said, no, well, we'll just come up with this real simplistic solution, and we're just going to tax all trusts, and by the way, estates, not just trusts, we're going to tax all estates at a really high rate. And back then, the rule was $7,500, and it's gone up with inflation. Again, I'm telling you all this for the younger people in the audience don't really know the history about this, because it's kind of a nice thing to explain to your clients, because they're going, what are you talking about? Why did it get this way? Well, that's how it got that way. So here it is. What is this now? 32 years later? 30, I don't know, my math's not very good, but we're maybe more than that. And we're still at the 36 years later, when we're still at the same rule, okay, of taxing all trusts, and by the way, all estates. So, tell me, so there's a tax avoidance purpose involved in dying? I'm going to die just so my kids can save income? I mean, it's a ridiculous argument. But that's how the law got to where it is, and it's still there, okay? And by the way, I'm on the AICPA committee, and we've been trying to change that law. Where it hits the hardest is not just young kids, which is so outrageous, taxing our 4-year-old kids at 50% or whatever it is, but special needs trust. All of us in the audience know that if we have people with special needs, we have to use trust for a lifetime, and to tax those kids at a 50% rate is just outrageous. So any of that, how do you get around all that? So that's a big part of the book. And basically you do is you turn to, and this is a big part of my course I teach at Villanova. Anyone can take that course, by the way. It's called Income Taxation Trust. It starts in a month. But what we talk about in that course is that how do we avoid that? Well, it's Section 678 of the Code. So most of us in the audience are familiar with the grantor trust rules, and we're at least a little bit familiar with 678. And all that says is if we give the beneficiary a power to withdraw the income, then the income's not even taxed in a trust. it's taxed to the beneficiary. So again, if you look at 678 and the regulations closely, and this is all explained in the book, but 678 is not an all or nothing, okay? It can be a portion. So we actually just have a portion of the income, basically the income that's taxed over, basically the income that's over $12,500. That part of the income, we're going to have the beneficiary have a power of withdrawal over and cause that income to be taxed at the beneficiary's rate, which is never going to be higher than the trust rate. Especially important for all our clients with young kids and special needs children. So that's basically how you do it. It's a lot more involved than that. You start getting into estate tax issues, but all those forms are in the book. And what I explained in my book is I could care less if people, I have absolutely no ego, and I could care less if people do things the way I do. That doesn't matter at all to me. But what does matter to me is that we can't, as estate planners, we can't accept these unbelievably egregious rates on our spouses and children and minor children and special need children. We just can't accept that merely because we want to use trust for all those reasons we talked about at the very beginning of the seminar. So that's equally as important of an issue and totally addressed in there. And then it also addresses how do you combine that if you want to pay IRAs and 401ks to the trust. How do you accomplish that too with that same type of trust? And that's all explained in the book. So it's a big reason I wrote the book and why I've written all these articles over the years for lawyers is that we cannot accept that outrageous situation that was created by just a few lawyers back in the early 80s created the situation that we're in now. And again, looking at the situation now where an individual has to have over $500,000 of taxable income to be in the highest bracket, but a trust, and that's what we do for a living, we represent people that are going to pass, and we're setting up trusts for spouse and kids, but a trust, the rule is $12,500? I mean, are you kidding me? So people have other solutions. They either don't use trust or they just pay out all the income of the trust currently. Well, you could do that, but the problem if you pay out all the income is most clients don't want that. I don't want my trust to pay out all the income to my 4-year-old kid or my 18-year-old kid. I don't want that. That's why I'm using the trust. So these other techniques accomplishes what you want and protects the assets in the way you want, gives you the control you want, but doesn't force the hand and basically destroy the old reason you do a trust. And again, that's why I have the whole chapter 5 of that book is focusing on retirement benefits because that's where most of our clients' money is. It's in their retirement plan. And so if you can't address the same issues for retirement plan monies, then you really miss the major asset in the client's estate. Okay? Are you about up? Or do you want me to go on more about it? We're all about up, right?
We've got just a couple minutes, so if you had any closing comments, we've got about 2 more minutes in the session.
Okay, I just want to, again, mention that I really appreciate everyone coming today, but my goal on this whole thing, again, was I just think that people look at the law, and I mean, I've been seeing all the other comments and conferences out there, and I just feel like these major, to me, these are huge issues. Using trust because that's what we do in estate planning, but at the same time, we don't want to give up on all these income tax basis issues and ordinary tax issues. We want to protect our clients from lawsuits and second marriages and divorce and all these issues in estate taxes. The other reason I wanted to give the speech was I wanted to have a renewed emphasis on state tax laws, and the reason for that again is that you don't see a whole lot of movement in these states. That you see some, but not a whole lot of movement in these 15 states. Some of them are very large states that do have state taxes. So I just don't want us to get fooled thinking we don't have an issue today, but we really do because we really never know where our spouse or kids are going to end up living. And so I want to have kind of a renewed focus on that in our estate planning.
Excellent. I'll remind anybody, if you have any questions, you can email them to estateplan@stratfordpub.com, or you can submit your questions by typing your question into the Q&A box in the bottom left corner of the screen and clicking Send.
And there's a lot of other material on the website, too, a lot of other articles that get into all these issues in more detail. There's one article called the Minimum Income Tax Trust, which you may want to look at that article on the website, too, because basically everything we talked about today, other than this second part of the article, is in there in more explanation and more forms. The forms in the book, though, is more current. That book was published in May of last year. And, again, I am going to come out with a new edition of that as soon as I have time.
Sure. We got one last question.
Sure.
The course you just mentioned. How do I register for the taxation of T&E course?
I don't know exactly, but just go to the website. So to type in Villanova University School of Law Graduate Tax Program, and there's materials on there on how to register. And the course starts in a month. It's online, so anyone can take it throughout. It doesn't matter what city you live in, and it's designed for basically primarily designed for practicing lawyers and practicing CPAs. And we just get in much more detail in all this subject matter.
Excellent. Well, thank you very much for a great presentation. I'm just going to advance the slide once more. I want to thank everybody for attending today. We hope you've enjoyed our national webinar, Estate Planning and Tax Reform, Wealth Transfer Structures under the New Tax Law. If your question was not addressed today, you may email it directly to our presenter. His email address is included in the presentation materials. If you're seeking continuing education credit, you must verify your participation in this webinar by completing and submitting the attendance affirmation evaluation after the program. A link to this form will be included in the thank you email that you will receive immediately following the program. As long as you have registered and paid for this program by 5 p.m. today, you will receive your certificate of attendance within 24 hours. If you have any questions about continuing education credit for this webinar, please call our Continuing Education Department at 404-881-1141, extension 2. Again, for those of you seeking standard tax or accounting continuing education credits, you will need to have responded to all of the pop-up prompts during today's presentation. Today's participants can order a recorded version of this event at a special attendee price. Please call our customer service line at 800-926-7926, extension 1, or visit Stratford's website at stratfordpub.com. If you are not yet an annual Stratford Pass holder, please try the CLE Individual Annual Pass. You can get all of your CLE credits for one low price. Simply respond to the email that you will receive after this program. Stratford would like to thank you for your attendance today. To end this call, simply hang up the telephone. Thank you and goodbye.